Fani Willis got slammed in an amicus brief in the Court of Appeals in Georgia. The ACLJ is saying Big Fani needs to be disqualified, okay? Judge McAfee really done goofed here, and he's got to reverse himself. We have to save the entire institution of law because Fani just sat there and lied to everybody and lied to the judge's face. And how can anybody have faith in the legitimacy, the credibility of what's coming out of Fulton County? No one can. And so we're going to go through this filing. It is a fun one from the ACLJ, the American Center for Law and Justice, and they're doing great work. I'd encourage you to follow them. They're right next door on YouTube. They're right next door on X. They're all over the place. Just give them a look up and go give them a follow because these are lawyers that are on the front line fighting this stuff, and we need them. We need more of them, and we need to support them. So who is behind this? Let's take a look at what's hitting Big Fani Willis in the Court of Appeals in the state of Georgia. We got a 28-pager here that we're going to hit through. We got the case, of course, Donald Trump appealing this versus the state of Georgia, Big Fani, and this is up on appeal from the disqualification argument and debate. And this is not a party to the case, but this is a brief of Amicus Curiae, okay, friends of the court, who are saying, look, we have an interest in this because this is going to wreck the law, right? We have an interest in the law. And so these amazing people are all submitting this. You see Jordan Sekulow, Stuart Roth, Andrew Economo, Benjamin Sisney, and Garrett Taylor, all from the very great American Center for Law and Justice out of DC. Good stuff. But you might be asking yourself, well, who is the ACLJ? Why are they doing such a great job? Well, let me tell you. Amicus Curiae, the Friends of the Court, it's an organization here dedicated to the defense of constitutional liberties, the real kind, secured by law, including the integrity of our constitutional structure. You know, the separation of powers that suddenly got evaporated overnight when Trump came on the scene. ACLJ attorneys have appeared often before the U.S. Supreme Court. They were there as counsel for the parties in the Anderson ballot removal case, Trump versus Vance, and many others, okay? We recognize some of these cases, saying that they've appeared in front of SCOTUS addressing various constitutional issues. You know, what this paragraph is doing is saying, hey, we know what we're doing, okay? We were there on the Anderson ballot removal case, so we're kind of smart because that decision came in their favor, you know, 9-0. Womp, womp to Judge Ludwig and Weissman and all that crew who were sitting around with Lawrence Tribe from Harvard saying that this was going to be unassailable, irrefutable, blah, 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 right? 9-0. But anyways, the point is, okay, these guys know what they're doing. They've been in all these cases. Boom, Fisher, McDonald, Pleasant Grove, okay, SCOTUS, boom, SCOTUS 2009, SCOTUS 2024. The Fisher case, I think, is the big one on the J6 charges, right? That is now on appeal, which might get reversed, which might decimate a huge portion of the J6 cases. So these guys are serious players, serious business. And they're saying, hey, Court of Appeals in Georgia, be advised, we're knocking on your door. Saying the ACLJ's specific concern here is the integrity and the preservation of the judicial system in a case here with national implications. The ACLJ files this brief on behalf of its members, right? It's an organization who reside in Georgia, as the district attorney at issue in this case, that's Fani, quite literally, and she represents quite literally, Fani does, the entirety of the people of Georgia. Now, the ACLJ also files this brief on behalf of its members who do not reside in Georgia, but who are concerned about their ability to meaningfully vote for a president that may be hampered by a politically motivated and infected prosecution, still very much bearing an odor of mendacity. It still stinks, okay? Nathan may have left the building, but it stinks, man. That Fani is noxious. So to preserve justice and confidence in the judicial process, Amicus Curiae urges this court to grant review. And now this is what the ACLJ has to say. It says, now, Your Honors at the Court of Appeals in Georgia, says this court should prevent the maladministration of justice by granting review to correct the trial court, that's McAfee, and his failure to disqualify Fani based on a glaring conflict of interest, or at a minimum, at least the appearance of a conflict, which he agreed existed, which is why Nathan Wade had to go. This court's discretion to grant review, talking to the Court of Appeals, gives it authority to correct this problem, especially when you have a case of such importance that the immediate review should be had. That's why we're here. This case presents such a question. Now, the existence of a conflict of interest, including an apparent conflict, is an issue of structural magnitude that infects the entirety of the criminal proceeding. If you have a lying Fani, if you have a perjurer that will literally grab documents and scream them around, wave them around like a madman in the courtroom, oh, it's a lie, like a lunatic, then you have to have questions about the entire proceeding, okay? Because she's conflicted, she's a liar, her integrity is called into question, so everything from the very beginning needs to go. But a conflicted prosecutor who nonetheless proceeds with prosecution casts an odor of mendacity, that's Judge McAfee's words, not the ACLJ's, over an entire proceeding that cannot be corrected or remedied after the fact. Beyond its unconstitutionally injurious impact over Trump and the defendants, the odor from Fani and Wade and their impacts negatively impacts the public perception and the confidence in the judicial system, especially when the prosecution is that of a leading national candidate for the highest office in the land. That's Trump. And we've talked about this as a double-edged sword, so to speak. In a way, Fani, she's so corrupt that it almost automatically delegitimizes this case, right? Like right now, right? Because the judge didn't dismiss her, but it's so, everybody's kind of going, okay, right? Even the sycophants on the left who were Team Fani pom-poms, all those weirdos that you see on X all the time, and on MSNBC, they're all silent. They're not talking about this case anymore. In fact, Andrew Weissman was like, maybe Fani should still go. I think, she wasn't disqualified, but maybe she should still go. And she has not gone because that's how bad she is. So the structural defect can only be corrected, they say, by rooting out all the sources of the conflict, not just half the taint. Neither a slap on the wrist nor removal of some of the conflict is going to suffice. Just send Nathan home. Now, he's happy, okay? He's doing cartwheels. He's probably on a cruise again out in Belize again. Maybe he's found a new Fani. Who knows what the heck he's doing. So as the U.S. Supreme Court has noted, some errors are so fundamental and pervasive that they require reversal without regard to the facts or the circumstances of the particular case. Yeah, that might be Judge McAfee, right? Going, what on earth? How did this guy even come to this conclusion? We went through this opinion and I was like shocked that he even thought that passed logical muster. Because I think he's a competent guy. Like, he's not an idiot. He knows what he's doing. But he just had to buckle for whatever reason and had to dump out that opinion out of his Fani. So an error is fundamental if it undermines confidence in the integrity of the criminal proceeding, which nobody has confidence in this, not even the left. As the Young court found, the appointment of an interested prosecutor raises doubt, and it constitutes such an error. So we got to reverse this. So the ACLJ continues, writing to the Georgia Court of Appeals, saying, all right, Your Honor, listen, there is a reason for severe treatment of prosecutorial decisions undermining confidence in the integrity of the criminal proceeding, including those which generate even the appearance or an odor, a stinky Fani odor, of impropriety, right? In other words, we punish bad prosecutor decisions for a reason. Why? Our entire system of government depends on that integrity. And I know I scream about this all the time about the legitimacy of our government. If the government doesn't have legitimacy, there's no reason for them to exist anymore. They become tyrannical. It's either they're legitimate and they have credibility to do the governing, or they're illegitimate. And unless you have a critical mass of people who believe in legitimacy and credibility, that's it. It starts fracturing apart. It is a fundamental premise of our society that the state wield its formidable criminal enforcement powers in a rigorously disinterested fashion, like rigorous. For liberty itself may be at stake in such matters. Now, prosecution by someone with conflicting loyalties calls into question the objectivity of those charged with bringing a defendant to judgment. They say the critical need for integrity and the values served by the application of conflict jurisprudence applies with special force to this case. We have laws that help us deal with conflicts to preserve the integrity and the values, and that means we have to consider it even harder now because it's a Trump case, national importance involving a national election and right in the middle of an election season. Saying, to be sure, these principles must and do govern in the prosecution of anyone, okay? Like their base layer prosecution. Everybody deserves this. Justice is supposed to be blind, right? Everyone deserves due process. He's not delaying his case. He is exercising his right to a fair trial. But they apply at least as strongly, if not more so, to the prosecution of a national candidate in an election year, right? Where the entire country is watching this, where half the country has questions about the legitimacy of this, and where he's representing 80 million Americans plus. So you want absolutely the justice to be blind. You don't want Fani and Wade cavorting around, making money off the continued prosecution. If the prosecution gets dismissed, there's no more checks for Nathan. Now, millions of Americans from the other 49 states who have no ability to influence Georgia's local political conduct are watching this case and will be directly affected by its outcome. Now, the bad choices, the prejudices, and the personal political motivations of Big Fani and Georgia's McAfee impact the entire nation and the integrity of Georgia's criminal justice system, implicating its prosecutors and its courts, is also at stake. So the ACLJ continues in their appeal, challenging Big Fani, writing to the Court of Appeals in Georgia, saying, even an appearance of impropriety is unacceptable here. In criminal cases, it erodes the confidence in the whole process. Says the United States Supreme Court has wrote on this, and they've emphasized that even the appearance of impropriety can be constitutional grounds for the disqualification of a prosecutor. We talked about that in the U.S. Supreme Court case called Young. They say an appearance of conflict is just as dangerous to a criminal proceeding and the integrity of the judicial system as any other conflict, because such a conflict still pervades the trial and it prevents the fair administration of justice. Saying a prosecutor like Fani and Nathan, two of them, the big ones, right, the highest people on the case, the DA and the special prosecutor, both committing these perjurous statements and engaging in this conflict, both of them impaired by an actual or even an apparent, they have created a structural error. The entire indictment is now in question, right? If the food comes to you and the seal is broken, you don't eat it. If this indictment comes to you and Fani and Wade have been cavorting and indicting each other all over it, it's not valid, right? It affects the entire process of a criminal proceeding. Saying appointment of an interested prosecutor, someone that has a stake, is also an error whose effects are pervasive. And such an appointment calls into question and therefore requires scrutiny of the conduct of an entire prosecution rather than simply some discrete prosecutorial decision, right? They'll say, well, does Fani and Wade, does their indicting each other, does that actually cause material problems to the case? Judge said no, really. He said no. As long as Nathan Wade goes away, everything else, all of their other corrupt decisions, and remember their stupid calendar meetings where she's like, we're meeting with the public corruption team in Fani's office with Nathan for 2 hours, her and Nathan having lunch together. And he probably billed for that, okay, while they're indicting each other all, at 4 a.m. So everything needs to go. You wouldn't trust that for a minute. ACLJ says it is particularly necessary to hold prosecutors accountable for their conflicts of interest because, quote, a prosecutor exercises considerable discretion in matters, such as the determination of which persons should be targeted in their corrupt investigations, which persons should be charged with what offenses, what persons should be utilized as witnesses, and whether people should have immunity. Unlike other evidentiary defects that can be excised from a particular moment in a case, the harm that results from a bad prosecutor, the Fani noxious odor, it ultimately permeates and it taints the entire proceeding. As the Young court explained at the SCOTUS, they said between the private life of the citizen and the public glare of criminal accusation stands the prosecutor. The state official has the power to employ the full machinery of the state in scrutinizing any given individual. It is an insane power. And this is why we were so concerned that Fani would stick around, right? Yeah, she's a county attorney. Yeah, she's just a single DA in Georgia, but it is a huge position in a huge county. And that's why when she goes and she speaks out at the church, when a prosecutor uses the full machinery of the state and their big mouth, it's double, right? The defendant has no recourse. Their only defense is speech. And then they gag the defendants when they want to exercise their right to defense. SCOTUS says, even if a defendant is ultimately acquitted, forced immersion in a criminal investigation and adjudication is a wrenching disruption of everyday life. The process is the penalty, right? They don't even really care about Trump's ultimate conviction in some cases. As long as they can call him a felon before 2024 voters go into the ballot boxes, that's sufficient for them. If all of it gets reversed on appeal, they don't care. Case is over. As long as they can win the White House. Now, for this reason, we must have assurance that those who would wield this power, like Fani and Nathan, will be guided solely by their sense of public responsibility for the attainment of justice, which is obviously, this is a justice in their minds, which is social justice, societal justice, not legal justice, not something beholden to an evidentiary standard or beyond a reasonable doubt there, political justice. ACLJ says, appealing Fani, says, as agents of the state, people like Fani are charged with the administration of justice, and a prosecutor's ethical responsibility bears weighty force, especially if you're named Willis, in the interest of protecting and preserving justice. As the Supreme Court made crystal clear in another case called Berger, they said the prosecutor is the representative not of an ordinary party to a controversy, no, but of a sovereignty whose obligation is to govern impartially, is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. Saying the Georgia courts have embraced the structural importance of preventing conflicts of interests, whether they're apparent or actual, and made clear that an appearance of impropriety may certainly constitute grounds for disqualifying a Fani. Saying in this case, the court wrote, certainly a conflict of interest or the appearance of impropriety from a close personal relationship with the victim may be grounds for disqualification. They say this standard is time-honored, by the way, Court of Appeals. In 1852, the Georgia Supreme Court emphasized that the administration of the law should be free from all temptation and suspicion. person, not some, so far as human agency is capable of accomplishing that object. Now, upon that basis, the court disqualified a former Solicitor General from representing defendants that solicitor had charged during his time as a prosecutor, even though his term had expired, right? So this guy was a prosecutor, became a defense attorney, represented people he had previously charged, said, no, can't do that. This holding was not dependent on the facts of the case. It wasn't specific to that, like him representing them, whatever. It was based on the inherent appearance of impropriety. It looks bad. The dude prosecuted them before. So no positive abuse of his professional confidence has been made to appear, right? And none is imputed to him in this case, saying this dude didn't even do anything wrong. By the judgment, which we have felt it our duty to award, but we affirm the judgment of the court below, as we stated before, on the ground of public policy, okay, irrespective of the facts of this case. We're not alleging that this attorney did anything bad at all. This guy might be like really above board. He was a prosecutor, so probably not, but maybe he was. So the Georgia Supreme Court further clarified in a similar factual situation. They say, look, when an appearance of impropriety exists, which is what Judge McAfee admitted existed, and then he cured it by booting Wade, no representation should be permitted, regardless of whether there is evidence of wrongful intent. In other words, an appearance of wrongdoing alone is disqualifying. They cite the case called Conley. That's enough. 1894 case said removing a defendant's legal counsel and noting that the lack of evidence of a wrongful intent was irrelevant. It doesn't matter if the defense attorney who was removed intended to do something bad. It looked bad. They said, we have not the slightest idea that anything intentionally wrong or unbecoming on his part was intended. But we feel constrained, they said, to hold that he had no right to be in any way connected with the defense. Too close, okay? Even the appearance is bad. As it should be, the law should be above this. The standard should be ultra high everywhere. Now, likewise, this court is also emphasized. The Court of Appeals, they're saying, this is the ACLJ writing, appealing Big Fani as amicus to the Court of Appeals saying, you guys have decided this, that the administration of the law, and especially that of criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation and bias and prejudice so far as it is possible for our courts to accomplish it. Again, the mere existence of an apparent conflict was inherently disqualifying in that other case, regardless of the motive or the particular prosecutor. By proceeding despite an apparent conflict, the alleged conduct of that attorney was so at variance with that impartiality and the high ethical standard that we had to deal with it. Now, as the court explained and acknowledged, even when no conflict that's actual exists, a perceived conflict in the reasonable eyes of the public threatens the confidence in the legal system itself. When this danger goes uncorrected, it undermines the legitimacy and the moral force of our already weakest branch of government. This is a point we hit here as often as we can. The courts don't have any enforcement powers. The executive branch, the president, does. He can execute the law. They got the FBI, man. They got a DOJ. They got a lot of power, okay? They got too much power. It's insane. They've gobbled it up over the years. They don't deserve any of it or a lot of it. Congress has the power of the purse, right? We've seen what they can do. Liz Cheney starts subpoenaing people for her legislative hearings and everything. So they can do that, but the courts, they don't have that. They don't have either of that. They have to have legitimacy. They have to have integrity and credibility. And if the public stops believing in that, it's gone. It's over. And if the courts are gone and over, there's no justice system. Then what happens? Might makes right. Tyrants take control. We're living right in the middle of it. We're battling for it right now. That's what this entire election is about. Conflicts of interest, whether they're perceived or actual, have undermined public confidence and they've deepened public suspicion about the criminal justice system. And so accordingly, the issue in a conflict analysis is not simply whether the prosecuting attorney actually committed an inherently wrongful act or whether they actually made bad decisions. Now, we think that, yes, clearly they had, right? Fani and Wade, they made bad decisions. They know they did. They got broken up, whatever was going on. So we know it's bad, but the standard doesn't require that. If it looks bad, that's enough. The issue is instead the higher one. And why do we want a high standard? It's because we want to maintain the interest of justice. We want justice system to protect the public perception of its prosecutors and the perception of our judicial system. That interest can only be served by meaningfully extinguishing all of the apparent conflicts too. You can't have a bunch of people running around saying, I wonder if. It needs to be beyond reproach. So in recognition of these principles, the Georgia Supreme Court has reiterated, they say that Georgia courts have an interest and a duty to ensure that criminal trials are conducted with the ethical standards of the profession and that legal proceedings appear fair to all who observe them. Noting that even where a defendant is willing to waive counsel's conflict of interest, right? Even a defendant might say, oh, I don't care if that person's doing that thing. The courts won't allow allow it. Well, we care, okay? Such a waiver does not always cure the problem. This is why the Georgia statutory and case law vests the court with broad power to control this conduct, to control the conduct of the officers like Fani in judicial proceedings before them. Now, in this case, the Trump case, the Fani prosecution, merely stopping the continuation of the repeatedly made, quote, bad choices is not enough. The case is tainted from day one, from the very beginning. Nor is the removal of some of the conflict sufficient. The law deserves and requires more than that, much more. It requires the disqualification of all of the conflicted parties. Fani was the origin source of this. She hired Nathan. Courts do not allow factual disputes over what amounts to an actual conflict to diminish the policy and the constitutional reasons implicated by the appearance of impropriety, right? We don't want to get into that. We actually don't want to debate that. Is there a conflict? Like, okay, let's see. Did Nathan and Fani, did they actually, do the thing? Let's get some proof of their, actual intercourse and time, date, location, and what positions and whether the lights were on or not. Like, we don't care. If it even looks bad, that's enough. Okay, bad, you got to go. Go figure it out. We're not even going to get into it. Just get out of here. For example, in Love versus State, an attorney represented the state at a defendant's preliminary hearing and then began working for the law firm representing the same defendant. So prosecutor shows up at the defendant's initial hearings, prosecuting the defense, leaves the prosecutor's office, good call, works for a defense law firm, shows up on that same defendant's case, now defending him. Curious. He had access to the government's prosecution file. Now, the parties disputed factual questions about that, relating to the extent of the former prosecutor's involvement in it. Did he see it? Was he just there doing an initial appearance? Importantly, the factual dispute didn't matter. No one cares how involved he was. Like, he might have just been there filling in. Your Honor, I don't even know what this case is about. Happens all the time. Like, I've stood in for other lawyers. Someone will text me, hey man, I'm not going to make it to the court. My client's there. All we need is a 30-day continuance. They just gave us discovery. Can you fill in for me? Sure, no problem. I'll fill in. Hey man, what's your name? My name's so-and-so. I'm a friend of your attorney. He's going to be 15 minutes late. Judge is going to call us. Let me handle this. You have any questions for me? No? Okay, handle it. Okay, but I don't know that dude's case file. I don't know anything about it, right? And you just ask for a continuance. It's no problem. Not a big deal. Attorneys do this all the time. This is like, attorneys being bros. At least defense attorneys do. Who knows about prosecutors? But happens all the time. So maybe, prosecutors filling in. He doesn't even know anything about the case. I wasn't even on the case. No one cares. The fact that you were a prosecutor matters. Sometimes an attorney who's guiltless in any actual sense, right? Don't even have to be at fault. Nevertheless is required to stand aside because you have to do that for the sake of public confidence in the probity and the administration of justice. You might be totally innocent. Sorry, dude. Like, I know you want to be on this case and write a book about it, but you got to go. Fani, in this case, must be made to stand aside. Saying this court, in the ACLJ's appealing Judge McAfee's non-disqualification order to the Georgia Court of Appeals, says this court should ensure that the stinky Fani odor of mendacity that pervades this case is removed, and it needs to be removed before it's too late. Saying this petition's question is not whether an appearance of conflict exists, okay? That's, we know that exists. McAfee made that finding. He says, yeah, it does exist. There is an appearance. And so that decision is entitled to deference. We don't even have to challenge that. We'll agree. So the question is instead is whether that appearance of a conflict can be cured. Does telling us that Nathan Wade has to go fix this? While the very prosecutor who created that conflict by repeatedly making bad choices and by repeatedly creating that odor of mendacity, stinking up the place, she's allowed to remain on the case and hasn't even rinsed off. The trial court sought to correct the conflict by simply requiring that either Fani or the DA Wade, special counsel, with whom they fannied each other, withdraw. That was enough. But that remedial action remediates nothing, and having Wade leave is insufficient to correct the actual constitutional problem that exists here. Saying McAfee ruled that Fani's conduct, he put this in his order, Court of Appeals, not us, says that Fani created a, quote, significant appearance of impropriety. Not just a minor appearance, but a significant that infects the current structure of Fani's team. Now, nonetheless, right, even though McAfee's like, yeah, I see it, the court declined to remove her from the case. We're all scratching our heads reading the opinion going, what? Herein lies the error of McAfee's decision. The court's finding that an appearance of a conflict is well supported. It's based on ample evidence. Let's talk about it. Saying even if the romantic relationship began after Wade's initial contract, right? So the debate was, did this start in 2019 before Nathan Wade's appointment, or did it start in early 2022 after the appointment. They say, but even if it started after the appointment in 21, Fani chose to continue to supervise him, continue to pay him, and maintained their indictment relationship. She further allowed the regular and the loose exchange, that's for sure, of money between them without any exact or verifiable measure of reconciliation. This lack of a confirmed financial split creates the possibility in the appearance that the district attorney benefited, albeit non-materially, from a contract whose award lay solely within her purview and policing. Saying most importantly, were this case allowed to proceed unchanged, the prima facie evidence concerns that are raised by the defense would persist. And as Fani testified, she came in, right? She said, our relationship has only gotten stronger. Our relationship is stronger than ever. She loves this dude, and that this relationship has been cemented after these motions, and it's stronger than ever. They're probably back together, aren't they? So examining the evidence, the lower court McAfee found that, quote, an outsider could reasonably think that Big Fani is not exercising her independent professional judgment, totally free from compromising influences. Thanks, McAfee. Yeah, that's true. Yeah, I think that's a good line. Yeah. The court concluded that neither side was able to conclusively establish by a preponderance of the evidence when the relationship evolved into a romantic one, which is such BS. Okay. Preponderance of the evidence is the lowest standard of the law. It's 51% likely is the number that we use. That's it. If it's like more likely than not, like 51 to 49, okay. Happens all the time. Okay. And we had a lot of evidence on that one. We had Robin Yurdy, who testified, said it clearly started. Terrence Bradley's testimony to Ashley Merchant in his text messages confirmed that, said the same thing until he was clearly lacking credibility and, in my opinion, lying on the stand. So there's more evidence than not. There's more statements than not. So it's judges copped out on that one. But anyways, he agrees. An odor of mendacity remains. So pathetic. Anyways, it's disappointing from him, but all right. Also noteworthy, the court specifically concluded that the DA's testimony had not proven credible. Okay, so if she's a liar, then why is this obviously not held against them? But reasonable questions, he says, about whether Fani and her hand-selected lead, Nathan, testified untruthfully about the timing of their relationship further underpin the finding of an appearance of impropriety. Judge McAfee said, yeah, again, it exists, but he's just going to cure it by making Nathan go home. The impropriety of the DA's action did not end there. The Superior Court also found that Fani and her conduct of giving a speech at a church where she said, why, God, are all these people condemning me for the black man? And we said, what? Because you're sleeping with him. That's why. Obviously, commenting extensively on this case was also legally improper, and providing this type of public comment creates dangerous waters for Fani to wade further into. Well, I didn't catch that the first time we read that. Maybe we did. I can't remember. Dangerous waters for Fani to wade into again. So those findings serve as a basis for why the Court of Appeals in Georgia should examine this. After detailed examination of the witnesses and lengthy testimony that we covered here extensively, the court found that Fani Willis's actions had created an appearance of impropriety and that an odor of mendacity, the stinky Fani, was still present in this case, as well as the continuing possibility that an outsider, like us, could reasonably think that Fani is not exercising her independent professional judgment totally free of uncompromising influences, saying, come on, the U.S. Supreme Court is clear. Once a conflict of interest, including an apparent conflict, is established, we have deemed the prosecutor subject to influences that undermine confidence in a prosecution can be conducted in disinterested fashion. If a prosecutor is shown to have a conflict of interest, her presence cannot continue. Otherwise, when a conflict exists, we cannot have confidence in a proceeding in which this officer plays the critical role of preparing and presenting the case for the defendant's guilt. The court below, in the appeal to the Georgia Court of Appeals, cited several civil cases where an appearance of a conflict on the part of private representation did not necessarily result in that attorney's disqualification, so cases that are not like ours, but instead that could be corrected with some other remedy. But those are civil cases with very different dynamics, Judge McAfee, and different constitutional and policy issues at stake there. For one, civil cases don't involve state actors like Big Fani representing the entire body politic of a sovereign state in a criminal proceeding pursuing the interest of justice, right? Those are two private parties suing each other. Life and liberty are not at the table. You don't imprison people in civil claims, but Fani can. Underscoring that material difference between civil and criminal cases, a conflict of interest among private parties affects only those parties, and it can be waived. But a conflict of interest in a criminal proceeding affects the public's interest in the faithful administration of the laws. That's us. And in no circumstance can we, the people, waive that concern. Saying the continuance of a prosecutor like Fani on a case, despite the odor of mendacity emanating from the appearance of impropriety, is an error that pervasively affects the entire proceeding here. It is a drastic error too, for which the only remedy is a drastic one, which is the replacement of the prosecutor. Disqualification cannot be based merely on a harmful error analysis. Saying a concern for actual prejudice in such circumstances misses the point. For what is at stake is the public perception of the integrity of our justice system. We don't care whether there was an actual problem. It is the perception alone. It is not lawful or consistent with public policy or with sound professional ethics for a prosecutor to continue despite an appearance of a conflict, regardless of whether anything intentionally wrong or unbecoming was even intended. The intention of the prosecutor is irrelevant. The administration of the law should be free from all temptation and suspicion, so far as human agency is capable of accomplishing that, and simply removing Wade, with whom Fani had made bad choices, even repeatedly. That's in quotes. Yeah, a lot of bad choices were made. While the repeatedly bad decision maker, Fani, she should know better. Like, she's the responsible one. Older brother, younger brother, do something stupid. Okay, you light something on fire. Just quick example. Who gets in trouble for that? Okay, older brother. I might have some experience on this one. Because you should know better. Why are you lighting that on fire right here in this location? This is not a location to light things on fire. Well, little bro doesn't have any responsibility for that. That's older brother responsibility. And allowing her to remain at the helm is woefully insufficient, saying the odor of Fani's stinky mendacity remains on this case and can only be corrected by removing and disqualifying Big Fani herself. For these reasons and others, the ACLJ Amicus Curiae respectfully urges this Court of Appeals in Georgia, to review this case and definitively correct Judge McAfee's erroneous decision and remove Fani to solve this conflict of interest. Signed, sealed, and delivered by Andrew Economou, Benjamin Sisney, Garrett Taylor, for the American Center for Law and Justice, ACLJ.org, also on YouTube, right next door, and on X, doing good work here, submitting an amicus brief into the Georgia Court of Appeals. And we're hopeful to see a lot more of this, and we're very hopeful to see the Georgia Court of Appeals accept this, and we'll see what happens after that if they do, because if they accept this, the argument would be that everything at the lower level proceeding in Judge McAfee's courtroom needs to be stayed. It all needs to be stopped, because until we decide whether Fani ultimately has integrity or whether she should remain on this case, we can't just continue on. So if they accept this, we'll see whether this case gets stalled out. But we'll be here continuing to cover this, my friends, and we hope you join us as we go live and release our videos here. Thank you for subscribing. Thank you for liking this video. Thanks for inviting someone to come over and join us. If you have a friend or family member who might be interested in following along, we'd love to see them here with you and joining us. We have great links down in the description below. Our members only community, where we do streams in the morning talking about other stuff that we can't get to here, is over at watchingthewatchers.locals.com, an amazing members only community. We'd love to see you here. We do Saturday shows. We have a great group of people there. We'll see you back here on the next one.